Hi, good afternoon once again, and welcome to our SEED online session. And I shared the link on the platform. And today we have our lawyer Echo Battles joining us. He will do a brief introduction just for us to know him, and then he'll proceed with the topic for today. So you have the platform, and go ahead.
Thank you very much, Paul, and good afternoon to all of you. And thank you for making the time to meet as a group and hear some of the things that I have to share with you. I think that you will find this session quite educative and useful, and you will come out with something that you can use or hold on to, to protect yourself or to even know how to deal with employers. And one day when you become employers, know how to deal with your workers. My name is Eko Battles Kojo. I'm a lawyer at a small by global standards, but it's a big firm in Accra here. And my area of practice has been commercial and company law, but I do a bit of everything, including copyright, other intellectual property issues, as well as other forms of litigation, including matrimonial cases, divorce, and other things of the like. Today, we're going to be talking about entering the workforce, navigating employment contracts, issues of workers' rights, ethics, and dealing with your employer. At any time, feel free to stop me if you have any questions. I hope that you can all see my screen. Now that I'm in full screen, I don't know if the messages in the text box will appear on my screen, but if they don't, I'm hoping that one of you or Paul would prompt me. You can obviously unmute yourself if you are in a place where we can all hear you well, and ask your question as well. I'm hoping that this session will be very interactive. I want to hear from you as well as, or as much as you hear from me. I think that even though maybe some of you are finishing university or something, you all may have had some experience working for somebody or doing something for somebody and getting paid for it. And so your experience can be relevant to some of the things that we discuss. And I would like to hear from you, whether you have questions or contributions. At one or two places during this presentation, I will ask that you go into groups to have a mini discussion and come back to me with some answers to some questions that I will ask. If that is all fine with you, I would like to start my presentation. So, quick run through of what we are going to discuss. We are going to discuss what a contract is, what an employment contract is, who the parties to an employment contract are, what maybe a job description, salaries, working hours, pay time off, vacation, place of work, duties, termination, and work ethics. So the first question I have for you guys, and I would like to start as strong and ask you guys to discuss for about 5 minutes and come back to me. What do you think a contract is, just in general? What is a contract? So before, what do you call it? I tell you, I would like to hear from you to know what you think. Paul, is this a safe place? Can we break out quickly and come back with some
Yes,
responses?
please. I can do that. And then
All
they
right.
nominate somebody to present, or
Yes,
can each person contribute as well?
each group
Yeah.
will nominate one person to present. But of course, if your group leader has forgotten something, feel free to prompt by sending a message to the group or unmuting yourself to add to what your group leader has said. Does that work?
Yes, please. Just the question again before I do the breakout.
The question.
Yes.
What is a contract? What do you think a contract is? I want to hear from you, Paul.
Thank you. For 5 minutes, initiating the breakout rooms now.
All right. Thank you.
3 groups. Here we go.
Yeah, good afternoon.
Yeah, so welcome everyone. Welcome Amy, Jonathan, Calvin, and the rest of us. So yes, can we start rolling? What's contract? Any ideas? I think of a contract is what it's a dictionary definition of a contract. Actually, start it if I'm to start.
They are interested in
Hi, lawyer. Can you hear me? Hello?
Yes, I can hear you.
Yes, just a quick one. So they are all done with their national service, and some of
Okay.
them are actually working, and then some of them are also looking for jobs. So they
Okay.
all have a bit of work experience, I would say.
Fantastic. That makes things a bit easier,
Yes.
I would say. So we have 3 groups, and I found myself in breakout group 3. The conversation was not flowing immediately, but we got some good answers. Can Francisca please start us off by giving the bigger group some of the discussion that we had in breakouts group 3?
Okay, so from our group, a contract is a legally binding agreement between 2 or more entities. There can be different types of contracts. One can be an employment contract that is between an employee and then the company the employee is going to be working for. There can also be a tenancy agreement between a tenant and a landlord. So basically, that's what a contract is.
Isn't at a period or a time. Contract goes with the time or period.
Sorry, Emmanuel, what did you say? Emmanuel? Mr. Appiah, you were saying something. I didn't catch what you said. Is Emmanuel there? Anyway, he was in our group. Another thing that was said in our group was that contracts can be spoken or written agreements, and that they are enforced by the law. So that was it for group 3. What about breakout room 2? Who is your leader? Hey, breakout room 2, did anybody gather the information to share with us?
Hello.
Hello, please, who am I speaking with?
Okay, my name is Ellen. I was part of breakout group 2.
Fantastic, Ellen. Please share.
Okay, so we came to a brief conclusion that a contract is sort of like a guide between 2 or more entities or parties, where a common goal or reward or like a common aim, okay, is legally bound within that documentation, and it's kind of direct, or should I say it's kind of like a rule book for them to follow to be able to go about their business. So yeah, that's the little bit we were able to discuss in our group.
Wonderful. Thank you so much. You said your name is Ellen.
Yes, please.
Okay. And then group 1, who is presenting on your behalf?
Okay, hello.
Speak out in one.
Group 1, I'm Bright. I'm speaking on behalf of Group 1.
Hello, Bright. Can you
Um,
please share what
yeah,
you had?
yeah. So for Group 1, we agreed on that the contract is a time-bound, legally binding agreement between parties. Okay. And since it's legally binding, there is that agreement that the parties involved agree to respect or to obey whatever has been agreed on. So that's what we actually did for Group 1 and what we agreed on as a group for Group 1.
Sorry, Bright, I lost you for a little bit. You said that since it's legally binding, the parties agree that. Right.
Hello, Mr. Lawyer Battles. Yeah.
Yes,
So
you were saying since it's
yes,
legally binding, the parties agree that.
yes, all parties agree to respect, to uphold, and to follow whatever has been agreed on.
Wonderful.
In a sense that since it's legally binding, then if one party goes against whatever we agreed on, we can take them on.
Wonderful. So I think the essence of what a contract is was captured by all the groups. Thank you very much for sharing. The main thing is that it is backed by the law and, can be enforced in court. So if a party breaches, another party can take that party to court to enforce the agreement, to enforce their rights under the agreement. But there are some elements that must be present in every contract for it to be legally valid before it can be binding on both sides. The first one is offer and acceptance. Party A says, I want you to do X for me, and I will pay you Y Ghana cedis. Party B says, yes, I will do it. So that's offer and acceptance. Consideration is something valuable that a party must give up. And in a valid contract, there must be consideration on both sides, okay? And capacity is the state of mind and the age of the parties involved in the contract. So we'll talk a little bit more about all of that. But the key thing to remember about offer and acceptance is that the offer that is made is the exact one that must be accepted for the contract to be valid. So if I say, can you give me a ride to Arabaka for 30 Ghana cedis? And you say, no, I can only do it for 35 Ghana cedis. Or yes, I'll do it, but I will do it for 35 Ghana cedis. The fact that you said that yes does not mean that we have a valid agreement, because what I offered you was not accepted. I hope that makes sense. So group 3, Francisca and I'm sorry, who else spoke in that group? It was Kevin. Kevin was right when he says that a contract can be an oral contract. You can have an oral agreement. Even sometimes you can have a contract without saying anything at all. And we witness this every single day. When you're in traffic and somebody calls the pure water seller. Sometimes you see that people buy pure water or bottled water from the sellers without saying anything. They point to what they want, the person brings it, they give the money, the person gives them the change, and they have engaged in a fully legally binding contract without saying anything. So contracts can even be inferred from your behavior, your action. If every day you come to my house, you cut my hair, I give you Ghana cedis. Every day you come, you cut my hair, I give you 50 Ghana cedis. We are contracting. We don't have to say anything, but we are contracting. So it can be written, it can be oral, it can be implied by behavior. But since today we are going to talk about employment contracts, you have to know that an employment contract for any job for which the time period is more than 6 months must be in writing by law. You cannot be employed orally if the contract is for more than 6 months. We'll talk more about that later. So, as I said earlier, consideration is something of value that a party must give up to enter into a contract. So, if it is a service contract, let's say I'm a barber and I'm contracting with Kevin. Kevin gives me 50 Ghana cedis and I give my services or my time. Both of those things have value. And you cannot validly contract without both parties giving up something of value to each other. It doesn't always have to be money, right? So we can enter into an agreement that I will give you gold for food. It is still a valid contract because both parties are giving up something of value. If we enter into an agreement, let's say I'm a farmer, we enter into an agreement where I am just supposed to come to your house and bring food to you every single week. There's no obligation on your part to give me money or to give me anything in return. Such an arrangement will not be considered a contract because while I am giving up something valuable like food and time delivering things to you, you are not giving up anything in return. And so if I stop giving you the food, you cannot take me to court and say, oh, but I was bringing you food every day, and so I must continue. I hope that makes sense to all of you. There must be something valuable exchanged by both parties in a contract. Capacity to contract is the next thing that is required for a valid contract. First, people must be of legal age to enter into a contract. In Ghana, the law on the legal age to enter into a contract is not entirely clear, but most people agree that the age is 21, with a few exceptions. But until you are 21, legally, you cannot necessarily make a valid contract, right? So you can enter into certain contracts where they are not void. They are not void, even though you are not of age. But you have the opportunity to void them when you become of age and cancel the contract. Ordinarily, somebody who is of age, dealing with somebody who is not of age, is at an advantage. And so the law sometimes, in some cases, allows the person who is not of age to cancel the contract once they reach the age of consent. In some other cases, you cannot, especially in cases where the contract is valid to you, the person who is not yet the age. That's 21. I hope I'm making sense. Now, apart from the age, there are other issues. There are things like impairments. If somebody is, let's say, has been drugged, or the person is so drunk that they don't even know what is going on, they have lost their capacity to enter into a contract, at least for that time. If a person is under a mental problem of a nature that takes away their ability to understand what they are doing at a time, they don't have the legal capacity to enter into a contract. And contracts entered with such persons can be cancelled when taken to a court. Okay? So now we come to an employment contract. Based on everything that I have said about contracts above, the first thing you have to remember is that an employment contract is a contract after all. So all the things that I've mentioned earlier must be present in the contract of employment. There must be an offer. The same offer must be accepted. There must be consideration. There must be capacity to contract. So usually what happens is that the offer is in the form of an employment contract or a letter of engagement that the employer shares with you, the employee. And it details all the expectations of the employee and also the terms of or conditions of service that you will serve under. So your pay, your vacation or holiday benefits, who is responsible for paying taxes, your hours of work, your place of work, the chain of reporting, etc., are contained in the employment contract, which is the offer. Once you sign that document, you have accepted. So there's offer and acceptance. Again, you have to be of age, even if you are below 21, but you are above 18, like I said, especially for employment contracts that are beneficial for the person who is below the age of 21. The law will enforce the contract against you if you try to use your age as an excuse. And then consideration. Usually for employment contract, the consideration coming from the employer is the salary that he will pay you. And then from the employee is the time and the efforts to do the work that they have been hired to do by the employer. In some agreements, the consideration from the employer, quote unquote, may not be in the form of money. It does not mean that the contract is not or non-binding. These days, even the sharing of company secrets and copyrights and design is all considered to be valuable consideration that the company is giving away. And so even internship, unpaid internship agreements can be valid even though there's no money coming from the employer, because the law says that there are other forms of consideration. At this point, I'll pause to see if anyone has any questions. Okay, I don't see any questions in the chat box, but if anyone has any questions, they can ask now. Otherwise, I will continue. Everybody is okay? All right, then I will continue. But feel free to stop me anytime. So who are the parties to an employment contract? First of all, the parties to any contract usually are the people who can enforce the contract. So if you enter into a contract, you and the person on the other side are the ones who can enforce the contract. If somebody breaches the contract, only the two of you can sign based on the contract. Of course, there are protections for the families of workers where workers are doing jobs that are dangerous, that can lead to serious harm for them. But those protections come from the law and not from the contract. The law allows, like if a worker is lost on a site, he dies, the law allows the family to get compensation from the employer, especially in situations where the employer is not providing a safe working environment. But those protections come from the law, not the contract. The parties to an employment contract are the employer and the employee. If the employee has some rights violated, the employee's mother cannot sue the company while the employee is there, because the employee's mother is not a party to the contract. The employee's wife cannot do the same because the employee's wife is not a party to the contract. It will be the employee who can enforce his rights and the employer who can enforce his rights. Usually. Sometimes there are exceptions, but generally speaking, this is the situation. So parties in an employment contract have general obligations towards each other. The employer's obligation to the employee is to pay the salary, pay the benefits, provide the safe working environment for the worker. The employee's obligation is to do the work at the time and in the manner instructed by the employer. These are general. Of course, there are other ones, but generally speaking, these are the main obligations of the parties to each other. You can look at them as the consideration that forms or helps to establish the validity of the contract, okay? In most employment contracts, you'll find a brief job description, sets out the obligations of the employee by giving what is expected of the employee. Oh, you are supposed to come to work at this time, come to the office 5 days a week, 4 days a week, 3 days a week, between the hours of 9 o'clock and 5 o'clock. And then there is also the chain of command. So who are you reporting to? The contract usually will say you are reporting to the finance manager, you report to the marketing manager, you report to the operations manager, etc., etc. Now, this is a big one these days in a lot of employment agreements. It is called confidentiality. Confidential information is information belonging to the company that is not public information that was shared to the worker in a way that shows that the information is a secret or a company secret. They don't always have to tell you that this information is a company secret or is confidential for it to be confidential. Some employment contracts will list a number of things and say that these information are confidential, and once we share them with you, we expect you to not to communicate it to the outside world. Whether or not it was a secret, once you have signed the agreement with this obligation, you are expected to keep this information confidential. Things like designs, client lists, finances, books, strategies of the company are the types of information that are generally considered to be confidential. In many of the agreements, they have clauses where they say you are allowed to share the information if it is requested by law enforcement or by authorities. So maybe GRA comes to the company, is doing an audit. GRA may ask a few questions about the company that is not public knowledge. Sharing that information with GRA would not constitute a breach of your confidentiality obligations under the agreement. So far, so good. Is everybody following? I'm not hearing much from people, so I'm assuming, but I want to check in to make sure that everybody is fine. Do you have a question? Okay, so Gideon says yes, Emmanuel says yes. Thank you very much. It's good to know that people are listening to me. So speaking of confidentiality and intellectual property, during the course of your employment, you may create some things. You express your creativity in one way or the other. There are different types of intellectual property. There are trademarks, there are copyrights, and there are patents, among other things. Patents and trademarks require registration. And so a lot of people only think of those two when it comes to intellectual property, but there are other things. Now, when it comes to copyrights, I hope people can see me. Can you all see me?
Yeah,
During this lecture or this conversation, I have written down some notes over here. Okay. I've listened to the different groups. I've written down notes. What I have written down, the moment I write, I put it down in writing, whether it is typing, writing it in a book, typing it on my phone. It is my copyright, my intellectual property. Copyright does not require registration. It only requires maybe originality, right? So I cannot write down lyrics from a Beyonce song or a Shatta Wale song and then say it is my copyright. But any original thing that I write down, it doesn't even have to be intelligible. It can be a group of nonsense words. It will be my copyright. Once it came from my brain and I put it down on paper, it's my copyright. Now, this applies to everybody. However, when you are employed by somebody and you create things or you write down things during the course of your employment, and no matter how creative it is, for example, there are people who are hired to make TikToks for their companies. Because you did that during the course of your employment, the TikTok, the copyright in the TikTok, the copyright in your notes, your whatever you create, you design, you build, as an employee, by law, it belongs to the employer. I want to be very clear on this. Okay? Once you are hired, you are an employee. You are hired. During the course of your employment, you create something new, something creative. You write down something. If I was employed by Ghana Food Movement and I made these slides, the copyright belongs to the Ghana Food Movement and not me, even though I'm the one who came up with it, because it came up during the course of my employment. During the course of your employment does not mean that when I go home after 5 o'clock, I go to my house and I'm writing my own poetry and stuff. That poetry belongs to my employer. That's not what it means. But while I'm in my office or while I'm working, while I'm doing things related to my job, all the creative things that I do, the intellectual property in them belongs to my employer. I know a girl who is very, very creative on TikTok, and she was hired by a company, a Ghanaian company, and she has been making TikToks for them. And the other day, I was telling her that every TikTok that she makes as an employee belongs to her employer, and she was shocked. But that is the law. Whether it is in your contract or it is not in your contract, the work belongs to your employer. Now, if you are particularly creative or you are particularly good at what you do, you have leverage. You can pick and choose what kinds of things go into your employment contracts. And you want to keep the copyright in the work that you make for the company or the intellectual property. You have to specify that in your agreement. You have to carve out an exception in your agreement. Otherwise, if the agreement is silent on this topic, everything you create will belong to the employer. I really hope I'm making myself clear. Anyway, so that is it for intellectual property. I'll pause again if anybody has any questions. Otherwise, I will proceed with the slides. Does anyone have any questions? Very good. It means that you are understanding me well. Hello?
Yeah, but it looks like your slide is still on the very first one.
Really?
Oh yeah, that's how you want it. Yeah.
The whole time it has been on the first one.
Yeah. Yeah, now we can see the subsequent.
Wow, I've been going through the slideshow. Can you see this page now?
Yeah, I can see where hectic. Yeah, I can see that.
Wow. Okay, I made a very nice slide with all these things for you, and it was not playing. Nobody said anything. Anyway, thank you very much. Any questions? Okay. So, work ethics. When you are hired as an employee, the employer expects the best of you at all times. It really goes without saying. No employer wants to hear that their employee was somewhere in public disgracing them, fighting, and doing all sorts of things. You are essentially an ambassador for your company, and you have to conduct yourself with the best behavior when it comes to the company itself, to your co-workers, and to the company's customers. So in your behavior to the company, don't steal. Don't, what do you call it? Lie. They're supposed to come to work at 9 o'clock. You come at 10:30. They ask you where you went. you say you went to see a doctor because so and so. No, it's not true. These are examples of unethical behavior. Unethical always itself with bright flashing lights saying, I'm unethical, don't do this. Sometimes it can creep on you. Your company, your role in the company requires you to handle money on behalf of the company. And then they give you the money, you don't use it all for everything you're supposed to use it for. You take some small here and there. And before you know it, you are in a big hole and you are owing your company a lot of money. I know somebody who was employed in an investment company, and on the side, she used to do stock trading. When I heard that she was doing stock trading on the foreign stock market, I thought that you are basically gambling. She said, oh, she knows what she's doing. So she used her own money, $10,000 or so, put it on the stock market, she lost everything. Now she was hot. And then she said she got a tip that, oh, this company is going to do well, so she has to buy. So she used company money, a lot of company money, and put it into the stock exchange. And the same thing, she lost everything again. Her plan was that, oh, she will invest it when she gets a profit, she will pay the company and nobody will know. It didn't work out like that for her. It's very unethical behavior. You should know, not to cross certain lines at work. It's very, very important. Okay. I've changed the slide. Can you see the new slide?
No, please. It's still loading at my end.
Okay. Jennifer, can you see the slides? The slide. Oh. Jennifer says she can see it. Gideon, you can't. Ben, let me get out and then I'll come back. So when it's like this, can you see it? All of you. Maybe I'll just keep using the full screen. So if I do this, you can see.
Yeah, I can see it.
Okay, all right. So the next slide is about salary negotiations. This isn't really a legal thing, so I will not spend too much time on it. We'll watch a slightly entertaining video about this, and then I will continue the conversation. But the one advice I can give you about salary negotiations is that don't go into an interview without knowing how much people doing the work you are going for are being paid in other companies and in the company that you are going for, if possible. You want to be armed with that information so that they don't give you a bad offer that to you looks good because your first big job or whatever, and then you find out later on that the people in the company are even being paid in dollars and you are taking cedis. If you, as much as you can, find out what people are being paid before you go into a salary negotiation. And I've added that ideally you should have some skill or experience that you can point to in your interview that you can use to raise your salary offer. Your ability to speak your local language, especially if it's a language that is not very common. Your ability to speak French or Spanish or other languages are all skills that people take for granted, but can be leveraged in an interview to raise your offer. So I'll go to the next slide, see whether I can play the video from here. Okay, I have to full screen, otherwise the video will not play. Can everybody see the screen? Jennifer, you can see the screen. Emmanuel, can you? Ben, you can. Wonderful.
Yeah, I can see the screen.
I'm looking at your resume, Veronica, and I just wanted to
Okay, so just a moment.
follow up on something. So I'm looking at your resume, Veronica, and I just wanted to follow up on something. It shows me here on your resume that you could speak Spanish. Yes, so I put that on there because I could speak Spanish depending on what you're offering. Are you able to give me some more information about your differentials for Spanish speakers? We offer $1 more per hour for Spanish speaking. And is that negotiable? It's not, it's really not negotiable. That's been the going rate for a while now. In that case, uno poquito yo explico español. I mean, I could probably approve up to 150. $1.50. Yo puedo hablar español un poquito más y un poquito más rápido.
I hear that the audio is not playing. So what I'll do is that when I finish my lecture, I'll share it with Paul. I'll summarize it and then I'll share it with Paul to share it in the platform. Hey, some can hear, some cannot see, some can see but cannot hear. Wow. No problem. So I'll summarize it and then I'll share it with Paul later on for you all to enjoy. But essentially, this person goes to the interview. They ask, how much do you offer more for people who speak Spanish? The interviewer says, oh, we can only do $1. Then the interviewee says, oh, then in that case, me too, I speak only broken Spanish. And so the interviewer raises it to $2 extra per hour before the interviewee starts speaking proper Spanish. So, you know, the point of the video is when you have certain special skills, let them work in your favor during interviews in order to be able to improve your offers. So I've seen a question from Emmanuel. Emmanuel's question is, should there be an insurance package for the employee in a contract in a situation as a field worker using the company vehicle? Emmanuel, the answer to your question is that there is no legal requirement, as far as I know, that the employer provide insurance for the particular employee. But typically what happens is that company vehicles should be registered comprehensively, especially vehicles that can be driven by any of the workers. And the idea is that anybody who is in the car who gets injured should typically be covered by the insurance in the event that something happens. I'm not an insurance specialist, so I will note this down and I will follow up with a colleague of mine who specializes in insurance, and I will get back to you. But my answer is that for now is that there's no requirement for a worker to be insured in particular for using the company vehicle. Emmanuel, I hope that Emmanuel Apia, I hope that that answer was at least slightly helpful. We will break up again at this point to discuss workers' rights. This time, I just want a list. So when you go into the groups, kindly list as many workers' rights as you can possibly identify. And when we come back out of the groups in 10 minutes, we can discuss a bit further. We will go through them. Last night, we took 5 minutes. I think 5 minutes was a little bit too short. So this time, Paul, I'm asking, or I'm kindly pleading with you to give the groups 10 minutes so that they can list as many rights. These are rights protected by law. So any workers' rights at all that you can think of. And let your mind go far. Don't be afraid. Let your mind go far and see how many you can list. And then when we come out of the groups in 10 minutes, then we can discuss them one by one. Paul, are you there?
Yes, please.
All right. So kindly
Yes.
break us.
Okay, so I'm doing 4 groups. The number has increased to about 30 now.
Wonderful.
So that everybody can contribute. Okay.
All right. Thank you.
Is anybody struggling to join their group? Kindly let me know so that I can move you. Yeah.
Paul, have we been able to do 10 minutes yet?
We have a minute more to go.
Okay.
And then, yes, they should be returning soon. I think there were 4 groups, but group 2 didn't seem so active. I don't know if they had a challenge joining the group or something. So maybe you can just ask if they were able to hold any discussion.
I think that's the case. I think that's what happened.
Okay.
So no worries. But I was in, I think, group 3 before, and I didn't hear much at first. But let's see.
Great. I think we are back. You can resume now.
We are back from the breakout groups. So it looks like group 2 did not connect somehow. But I'm expecting a lot from group 1 because it seemed very active. And group 3. So group 1, who is your leader? Breakout room 1.
Yeah, Mr. Batel, sir. Okay.
Yes, Gideon.
All right. So we gathered some rights for employees at the workplace. I hope you can hear.
I can hear you loud and clear. Let's hear them.
All right. All right. So the first one we talked about right for healthcare. You know, every employee should have quality healthcare. And to be under a healthcare plan, maybe, you know, it can be maybe the company you might be exposed to some risk with which you should have the right for healthcare when you know your system breaks down or something like that.
Okay.
And then the second one is the right to take a leave or time off. You know, you can't work actively throughout for the 52 weeks in the year. You need some time off to restore the lost energy along the way.
Right.
And then the next one is the right to receive a pay slip for the breakdown of your salary. You know, you might receive a pay slip. You might not know how much is being contributed to, you know, tax. If some are being directed into your, you know, your SNET accounts or any other benefits. So there is the right to get the breakdown of your pay slip to know what the deductions are being used for.
Right.
And then we have the right for maternity leave for ladies. You know, there might be ladies, married or unmarried, who might get pregnant while working, so with the right for maternity leave.
Right.
And then I don't know if this is a right, but we've deliberated and let me state it. The right to receive a 13th month salary. So you know, in Ghana, some companies I have not yet traveled outside Ghana, but some companies pay twice in December. So the right to receive 13th month salary, if it's been done, then everybody have to get an equal share of theirs.
Right.
And then the right to not be discriminated. So maybe when you go to a place, some places, you know, there are cohorts, people who are married are at one side, people who are not married are not preview or do not access some form of information. So the right to not be discriminated or the right to express oneself. So maybe the meeting that people who are, let me put the married thing there, who are not married cannot express themselves in a particular issue or topic. So the right to be discriminated. And then the next one is right to speak up against sexual harassment or to report people who are harassing employees or bringing down employees because of their status in the company. So the right to speak up against sexual harassment, against both male and female, not one-sided though. And then the right to know about company resources, so the logistics, the operations of the company within your department, maybe outside the department of the same company. And then that's what we gathered so far.
That's brilliant work. Thank you so much, Gideon. I especially love the energy and enthusiasm you brought to the discussion. I'm hoping that I can get the same thing from Group 3, but right now Group 1 is in the lead. So Group 3, what's up? Who is Group 3's leader? Mr. Baba, are you Group 3's leader? Hey, Group 3, did no action happen there as well, or what? Okay, you let me go to Group 4. I'll come back to Group 3. Group 4, are you there? Who is the leader for Group 4? Or is it that Group 3 and Group 4, once you heard Group 1's work, you people are afraid to present your work yourself? Oh, Mr. Apia, please speak. Or are you in a noisy place? Okay, Mr. Apia. I see that you are in a noisy place. So will you paste your answers in the group chat? Okay, I've seen your answers. Okay. So, Mr. Apia, which group are you in? Were you in? Okay, Mr. Apia says Group 4, their answers were right to sick leave, right to safe working environment, right to equal treatment regardless of gender, religion, or political affiliation, right to maternity leave, right to reasonable working hours, right against unfair dismissal, right against sexual harassment. These are all on points. What about Group 3? Jennifer, is yours for Group 3? Is Jennifer there? Okay. So since Group 3 and Group 2, nothing, no show, I will address the ones that you have shared. Jennifer, is yours Group 3, the ones you shared, or which group are you in? Madam Kisi, were you in Group 3 or Group 4? Okay, I will continue. Okay, Jennifer says Group 3. So Group 3 says right to maternity leave, right to sick leave, right to reasonable working hours. I'll address all of them, starting with Group 1. The first one you mentioned is right to healthcare. Believe it or not, healthcare is not considered to be a worker's right. Okay. You have the right to life, and nobody can deprive you of your right to life. But your employer does not have an obligation to provide health insurance for you. Next one, I think all groups mentioned right to leave or time off. There's the right to paid time off. And the paid time off is your leave, your annual leave. Every worker in Ghana who is employed for 1 year is entitled to a minimum of 15 working days paid leave. It's in our Labor Act. 15 working days paid. That's 3 weeks, Monday to Friday. Group 1 said right to pay slip or breakdown of salary to know whether your employer is paying SNIT, etc. you are definitely entitled to those benefits. So your employer must pay your SNIT, and if you are employed in a company, typically they pay your taxes as well, and you have the right to find out, and you cannot be punished for asking this information. So I'll give you correct marks for that one as well. The right to maternity leave. Each pregnant worker in Ghana, once the doctor has certified that she's pregnant, has a right to 12 weeks paid leave and can choose when she takes the time off. And even after the paid 12 weeks is over, she's also entitled to some unpaid time off, and by law cannot or should not be sacked because she is pregnant. That will be a violation of your rights as a worker. Okay. The right to 13th month salary. This one there. I don't think it's a right. It's a bonus. That's why it's called a bonus. It's a benefit that some companies confer on you. I've worked in Ghana for 12 years. I've never been paid a 13th month salary before. So it's most definitely not a right. It's a benefit that some companies give to their workers. Freedom from discrimination. This one too, multiple groups mentioned it. It is absolutely a right. You cannot be discriminated on grounds of your gender, your religion, your political views, etc., etc. Now, those things can become a distraction in the workplace. So, for example, when you are supposed to be working, then you are watching Alpha Hour and you're not using headphones. You have the right to freely practice your religion, but you are not supposed to use your working time to be doing your religious things. Yes, in some offices, they permit, you may take some time off to go and pray a little bit and come back to your desk. But you cannot let your religion get in the way of your employment. I hope that I'm making myself clear. So you have freedom from discrimination on religious grounds, but it must not interfere with the work. Freedom from sexual harassment is a big one. I'm sure some of you followed what happened with the bank, the elder of a church who is also a big man in the bank, and some side chick that he went to find. In your employment, the women, I'm speaking to the women now, you absolutely have the right and the freedom to be protected against sexual harassment. And I know sometimes some of the big men, and also the big women too, sometimes find it difficult to control themselves and they harass the young workers left, right, and center. It is a breach of your employment contract. It is a violation of your rights, and you can sue your employer, not just the big person who is doing the sexual harassment, but the company, if they know about this and they permit it to happen, they continue to allow this to happen. And then breakout room 1 said the right of knowledge of information, operational information of the company. That one, I'm not entirely in agreement. You are entitled to know everything that is required for you to do your work and to do your work safely. But apart from that, the company does not have an obligation to share all their information with you, especially when it comes to sales and, other information. It's not a right. The company may share that information with you, but you don't have a right to that information. So that's where I would disagree with you. Jennifer and group 3 said maternity leave, sick leave, reasonable working hours. Maternity leave, I think we've covered it. Sick leave, you have a right to sick leave, and but it's limited. And after a certain period of time, if you are not well, the company has the rights, unfortunately, to terminate your employment, because the whole purpose of them hiring you is to work for them. So if you cannot work, then they have to move on from you within reason. There are certain parameters and things that they have to follow. Right to reasonable working hours. In terms of the number of hours a week, you are correct. Group 3. The law says that everybody is supposed to work for 40 hours a week, and then the rest is bonus, and overtime should be paid. That means 9 to 5, that's 8 hours, 5 times a week, 40 hours. Or 8 to 6, that's 10 hours, 4 times a week, that's also 40 hours. But in terms of the time of day, there is no right to reasonable time of day, right? It depends on the needs of the employment, the business. For example, if you go to the Tema ports, the containers there are running 24/7. They need workers to drive the containers, to scan the containers, to weigh the containers, to carry the container from the ship onto the platform, from the platform onto the ship, 24 hours a day. It never stops. Just because your shift is from midnight to 8 a.m. does not mean that your rights are being violated. As long as you are working the 40 hours and they are paying the overtime. So that's it for group 3. Group 4, I can see that Mr. Appiah has contributed even more and more since we started this discussion. Mr. Appiah says, right to sick leave, we have taken care of that one. Safe working environment. This is one of the primary obligations of an employer. And one of the questions was about this. We'll come to that. What do you do when your employer does not provide you with a safe working environment? Right to sick leave, we've covered that. Right to equal treatment, we have covered that. Maternity leave, we have covered that. Reasonable working hours, again, we have covered that. Protection against unfair dismissal, we will end our discussion about on this topic. And freedom from sexual harassment, again, we have covered that. So I can see that in the groups, I mean, all the discussions were generally about the same thing. You people are absolutely correct for the most part, okay? Now, I will add that all human rights are also workers' rights. So in our 1992 Constitution, in chapter 5, that is Article 12 to Article 33, it lists all the fundamental human rights, and all the rights there are also workers' rights. So right to life is a workers' rights. Right to dignity, that is under Article 15. It's a workers' rights. Protection of personal liberty, your freedom. If you come to Ghana, they cannot take your passport away just because you are working for a foreign company. That is a violation of your rights as a worker in Ghana. Protection from slavery and forced labor. You cannot work for free as a slave. The company must give you something. And that something usually should be money. There is a minimum wage in this country. Of course, internships and all of those things tend to be treated differently. But strictly speaking, workers are to be paid for their work. Fair trial. Article 19 says that a court cannot convict you without hearing from you. It's the same thing if you are accused of something at work. They cannot sack you without asking you your side of the story, without investigating. If they do that, they are violating your rights as a worker. Okay. And there are other ones listed from Article 12 to Article 33. So all human rights are also workers' rights, in my humble opinion. So I'm going back to the slides. I hope all of you can see my screen. There is the right to form and join a labor union. It's a right under Ghanaian law, cannot be taken away from you. If you feel that you need to belong to a workers' union, you should absolutely have the right and the freedom to join the union. As for time off, we have talked about that's one. 15 days, 6 days, and public holidays don't count towards the 15 days time. Maternity leave, like I said, you are entitled to 12 weeks paid maternity leave. And if they sack you because you are pregnant, if you are sacked because you are pregnant, it is a violation of your rights as a worker, and you can seek redress. So with rights come duties. Hello?
Yeah, Barrister Battles, please.
Yes, sir.
Your screen.
Yeah, your screen is not visible. I can see the
Oh, okay.
slides.
Just a moment.
Right, sure. Thank you.
Just a moment. Share screen. Okay, I'm going to stop. Can you see?
Yes.
Okay, so
Yes, please.
we have not moved very far. This is where we were. And then I said, I mentioned these rights: for right to work in healthy, safe environments, equal pay for equal work, to join a labor union. We talked about paid time off / vacation. I said public holidays and sick leave does not count. Maternity leave, and I said if you are sacked because you are pregnant, and people do this, it is a breach of your rights as a worker. And then I came to this page. Before I talk about the duties of workers, I want to say something generally about the rights of workers. You think that lawyers are educated about their rights. Lawyers know their rights and they fight for other people's rights. And so when they don't play when their own rights are being violated. But I'll tell you right now that when it comes to labor law, lawyers are some of the worst when it comes to violating the rights of their employees. Some of the worst. Everything that I've just said is a right of the worker, apart from maybe the right to life, consistently is being violated by lawyers and law firms. The reason why I'm telling you this is for you to know that even though these are your rights and the laws are there, of course, unfortunately, there are violations. And even lawyers sometimes don't feel like fighting for their own rights. So even though you know that your rights have been violated, some lawyers may say, but this one, even me, they are doing the same thing to me at work. So first of all, be careful the kind of lawyer that you go for. But secondly, pick your battles. Do you understand what I'm saying? So for example, if your employer, and most employers do this, says, oh, today can you stay till 7 o'clock? We have to finish something. You can't say, it's my right. You can say it's my right. I'm only supposed to work 40 hours a week. But the way the job market is in Ghana now, if you do the work, some other person will come and do the work and work for those extra hours for free. So unfortunately, all of us, from time to time, in one way or the other, we get our rights violated. Doesn't mean that you shouldn't stand up for yourself when some other things are happening. If you are sacked for being pregnant, if you are sexually harassed, please take action. And at the end, I'll show you how to take action. Now, when it comes to duties, like I said, with all the rights that we have mentioned, rights and duties go hand in hand. So you have a duty to report to work on time. You have a duty to give your best effort at work. You have a duty to do what you can to raise the productivity of your organization. You have a duty to exercise care when you are doing your work. And you are duty bound to obey lawful instructions from your superiors at work. It's your duty. That's the whole reason why they have hired you. Okay? Now we are coming to termination. Termination just means the end of the contract or how a contract ends. There are different ways by which an employment contract comes to an end. One, both the employer and the employee will agree, and then the contract will come to an end. I recently told my bosses that I will not work for them anymore and that I'm going to do my own thing. So we all agreed, and now my contract is coming to an end. The law allows you to terminate as a worker if you are being sexually harassed or maltreated by your employer. You are allowed to terminate the contract. If the worker dies, the employer is not under an obligation to continue paying salary and taxes and benefits. So the contract may be terminated by the employer if the worker dies. If the worker is found to be medically unfit for work, this is not the same as being sick. This is the same as this means being sick for a long time in a way that prevents you from being able to do the work. The employer has the right to terminate the contract. If they brought you on to do video editing and they found out that you don't have the required skills or qualifications, they have the right to terminate your work for being incompetent or terminate your employment for being incompetent. And then either the employer or the employee can terminate the contract by giving 1 month's notice or paying 1 month's salary in place of the notice. So if the employer wants to terminate you, we can just give you your 1 month's advance salary and then the contract comes to an end. Or he'll give you 1 month's notice that at the end of the next month, he's going to end your contract and then you have to move on. If the contract is for less than 3 years, then 2 weeks notice is allowed. Okay. Termination and dismissal are not the same thing. Termination is the natural end of a contract. Dismissal is termination for disciplinary issues. If you are insubordinate, you are insulting, you discriminate, or you attack somebody at work, you are caught stealing, red-handed. The employer does not have to give you 1 month's notice. They don't have to pay you in advance. They can fire you on the spot, and it happens. And this kind of termination, which is called dismissal, has been endorsed by the courts. At first, there was a bit of debate, but now the courts say, if your employer catches you doing certain things red-handed, they are allowed to sack you immediately. Okay? So that's dismissal. I will skip over this for time. And then I will come to talk about remedies for unfair termination. I really hope everybody can see my slides. Can you all see the slide? Because I put valuable information on this slide. Paul, can you see my slide? Hello?
Yeah, you can see. Can see
Okay.
your slide.
Wonderful.
Yes, I can see remedies for unfair termination.
So, I've given you a summary of your rights as workers, and I've told you in certain situations under what circumstances you can be sacked immediately, and then in other circumstances, they have to give you 1 month's notice or pay you 1 month's salary. I've also told you that when you are accused of something but not caught red-handed, you have a right to be heard before they punish you, whether the sacking or suspension. If these rights are violated and you want to pursue, you have a number of options. You can sue based on the employment contract, saying that your contract has been breached, and ask a court to give you damages. That case can go to any court. It can go to a commercial court. It can go to a labor court. It can go to a general jurisdiction court. So that's one option. Sue based on the contract and try to get damages. That is the court to award you money in your favor. You can also bring a labor action to the labor court. This one is not based on the contract. It's based on your rights as a worker under the law. You go to the labor court and you bring a case to the court asking for certain things to be done in your favor, whether it is compensation, reinstatement, re-employment. If you are successful in the court case, then you may get what you are seeking. The next or the third option, so I said there are three. One, sue for breach of contract. Two, bring a labor action. The third one is you go to the National Labor Commission. I've put their phone number there, and I've said they are near Ridge Hospital. National Labor Commission is a body set up by law to investigate violations of labor and employment rights, and sanction. It has the power to sanction and punish employers for breaching the rights and contracts of their employees. Out of the three options that I've mentioned, to me, this is the most effective one. No employer wants to be taken to the National Labor Commission because they are very good at what they do and they lean towards the employee most of the time. So if you have issues with your employer, this is where I would recommend that you go. I've put their phone number over there. I'll share the slides with Paul to share with you. And they work faster than the courts and everything, in my view. So, and in a court, you may not know exactly what to do, especially if you don't have a lawyer. I always recommend that you go with a lawyer if you can afford one. But if you don't, the Labor Commission is the best place to represent yourself. You don't need a lawyer there. You can easily represent yourself at the National Labor Commission. So, in conclusion, today we have looked at contracts, employment contracts, who are the parties to the contracts, the rights and the obligations of employees and employers, and termination. How can you get involved or find out more? These are my contact details. If you have any questions, you can always send me a message by email or by WhatsApp. I have become very busy, so sometimes it may take a little while for me to get back to you, but eventually I'll get back to you. So feel free to reach me whenever. Thank you for taking the time.
Hi, Echo. Just a quick one.
Yes, please.
I think they shared some questions. I don't know if you were able to address them, or maybe you could just use the last 2 minutes.
I'll address every question.
No, I mean the questions that were shared throughout the session. I think Amy shared them with you.
Yes. Those ones. Okay. All right.
Okay.
So I've seen Jennifer's question. The question, does that mean that the deduction from the gross salary serves as a company paying your SSNIT, but not the individual. Jennifer, do you want to clarify your question a little bit? Is Jennifer there? Okay, I'll come back to Jennifer's question. Jennifer, when you say, but not the individual, I'm not so sure what you mean. So please, but I'll come back to Jennifer's question. The question that was shared with me earlier, does confidentiality or non-disclosure agreements and non-compete still apply if an employee is unduly dismissed? Undue termination does not necessarily terminate your confidentiality obligations under a confidentiality agreement or an employment agreement. When it comes to non-disclosure and confidentiality, those things often survive the termination of the agreement, regardless of how it was terminated. Right? You still have an obligation to keep those things private. But when it comes to non-compete, first of all, the time period is usually supposed to be about a year maximum. Anything more than that, and the court will not necessarily, enforce it. I believe that if the employment is unduly terminated, an employer cannot enforce a non-compete clause. If the employer unduly terminated the agreements. But of course, first of all, this will have to be tested by the law, but by my understanding of the law, no. You cannot give with one hand and take away with the other hand. You have sacked me wrongly, and I'm going to find work, and you said I cannot find work. That one there, I don't think that's, it should be allowed. How can an employee ensure his safety when an employer fails to provide a secure work environment? This is a dicey one. You as an employee, you have also an obligation to yourself to do everything you can to protect yourself. That means exercising due care during your work, etc. Now, of course, there are some things you cannot provide for yourself and your employer is supposed to provide. You don't have to wait until you are injured before you take the employer on. You can write to the employer, and I suggest that you keep your communications in writing, especially if you can be emailing your employers, because sometimes those things can form part of the evidence that you need. But if the environment continues to be unsafe, depending on the risks, I will advise you to leave the employment, because it's not worth dying over some employer who does not care about you enough to even provide a safe working environment for you. So that would be my suggestion. What are key aspects to keep in mind when negotiating contracts to protect against potential unfair treatment and breaches in labor rights? Look at the history of the employer. Of course, not every employer you will know. But if you ask around certain companies, you know that this company, the big men are always trying to chase the small girls. Right? That is one way you can, by doing your research, you can protect yourself. But if you are in the company and these things are happening, again, you have the right to take the employer on, either by suing him in court or taking them to the National Labor Commission. So yeah, what do you call it? He said, the question says, what are key aspects to keep in mind when negotiating? The thing about a contract is that If it is illegal, it's not enforceable. So anything illegal that the employer wants to put inside to exploit the worker cannot be enforced and will not be honored or should not be honored by a court. So also bear that in mind. How do you report an employer who owes his employees over a month to the appropriate quarters? I think I've answered that question in great detail. The National Labour Commission will be happy to hear from you and your co-workers. But obviously, bear this in mind that if you sue your employer or you take them to the Labour Commission, you are basically sacking yourself from the company. But if they owe you, and you're supposed to get your money. Now, I'll come back to Jennifer. Jennifer, don't worry, I'll come to your question. But let me look at some of the other ones. Francisca, what do you do in a case where there's a verbal contract and the employer reneges? It depends on what the employer has reneged on. Is this something that the employer was doing and then he stopped, or he never started doing? If he never started doing it, your case is a little bit more difficult because it is difficult to prove that your employer verbally promised you this thing. But if he was already doing it and then he stopped, you may be able to use evidence of him previously doing that thing and take him on to enforce that obligation or right that was promised to you. But again, always remember that taking your employers on is more or less sacking yourself. And even though it may even be illegal for them to sack you after you have sued them, they will just sack you. That's how employers are. And then you can add that to your list of grievances wherever you take them on. Azara, how long should it take for an employer to terminate an employee contract during probation? This one depends on the contract. The contract will usually say you have probation of 6 months. Before the end of probation, with about 1 month to spare, we will inform you whether you are successful or you are not continuing the company. So if the contract says 1 month, then by the 5th month, they have to inform you. Ellen, is it right to be in a company that pays your salary and fails to pay your SNIT and other taxes? It depends on what contract you have signed with the company. If you are an employee, the company must pay your SNIT and other taxes. And if they do that, they are breaking the law, they are violating your rights. However, if you are a contractor, you provide services, the company contracts you as and when, then when they don't need you, you're not, according to the contract, you're not there, then you are responsible for your own SNIT and other taxes. A lot of people who work on commission are contractors, and so their SNIT and taxes are their responsibility. But if you are getting a salary and they are not paying your SNIT and other taxes, they are wrong, and you can take them on. And for those ones, SNIT has help for workers like that, because SNIT is an entitlement, and if your employer does not pay it, what do you call it? You will lose out in the future. Jennifer, is there any difference between the company paying the SNIT and a deduction from the gross salary? So gross salary deductions include SNIT, but there is a difference because sometimes it includes taxes and all of that. So there is a difference, a little bit of a difference. And I think I have I've reached all the questions. Again, this is my contact information. If anybody has any more questions, feel free to send me a WhatsApp, send me an email, and I'll be happy to answer them. If there are not any other questions, I would like to say a big thank you to Paul and to everybody. I'm glad I did this, and what do you call it? Hopefully one day we can do this again, but if not, like I said, I'm going to share the slide with Paul. My information is that you can always reach out to me. And I have not forgotten the question about the insurance. I'll do my research and I'll come back with an answer to Paul, which can be shared with the group. So thank you all very much.
All right, thank you very much, Eko, for this amazing presentation and insightful discussion. Most of them have already started working, and I'm sure they can already relate to some of the things that you've discussed. Or if they had issues at work, they'll begin to align it with the next line of actions that they can take and advise themselves accordingly. So this is a session that was very much needed. For myself, I've actually learned a lot from this session. And on behalf of the youth, we are super grateful for spending your Saturday with us and taking us through this. Yes, thank you very much. And yes, and for the youth, thank you very much for joining this session. This is our 6th session, and we have 4 more coming from now until February. So do well to join the rest of the sessions, and then you benefit from this immensely. They are specifically designed for you guys. So I want you to take the most out of it, and so that you're not going to need this information where you'd have to pay money to get this kind of advice or information elsewhere, because we are bringing it right to your doorsteps through this program. So thank you very much and enjoy your weekend. Bye.
Thank you. Goodbye.